May it please the court, I am Daniel Eckert. I represent the County of Volusia and Volusia voters Philip T. Fleuchaus and T. Wayne Bailey. Subject to your questions, I ask to reserve 8 minutes for rebuttal.
So noted.
The court has jurisdiction. Volusia and these party voters asked the court that the court find, as did the circuit court, that the governor and secretary are proper parties, and that regardless, the intervener defendants are also proper parties. The Volusia County government that was established by Volusia voters is constitutional and entitled to endure. Volusia and the party voters asked the court to reverse the circuit court and hold that the special law approved by county voters pursuant to Article 8, Sections 1C and D that establish the county government remains in effect until are amended or repealed by these voters in a special election. I'd be pleased to answer your questions at the outset are to be directed as the court to those areas that are court of concern. Otherwise, I have a few points that I'd like to review.
Well, I'll jump in. I'm unclear about the purpose of the schedule that's in Section 6G, if it's not to provide the, I'm going to call them charter counties, with time to comply with the amendment.
Well, Your Honor, I think it can't, the argument that's been made by my opposing counsel, my friends, is that it serves no purpose if it doesn't do what Your Honor said, but it clearly serves the purpose of avoiding a frustration of purpose by not allowing the county governments to change or the legislature to change the form of government in the election preceding when the amendment would become effective. So it has meaning, and since the rest of the text is not clear and unequivocal that it is to have retroactive effect or to repeal impliedly in part Article 8, Section 1C, that it has meaning and it should be construed in pari material of 1C affords the county the benefit to continue its government.
But if that's the case, why does it allow Broward and Miami-Dade a longer period of time? Presumably that's because it's bigger in size, but that doesn't seem consistent with your argument.
That's a possible wording, but it's not the only wording, only reading. Mm-hmm. And so since it can be read to allow to avoid the frustration of purpose of which I just spoke, then the case law indicates that it should be reconciled with Article 8, Section 1C, and that it should not be given prospective effect. It's a possible wording, as Your Honor says, but it's not the only possible. It's possible reading, excuse me, but it's not the only possible reading. And in any case, it's not that it's the ballot text, since I think that portion is ambiguous. It is also supposed to be reflected in a clear ballot statement. The Supreme Court, in 3 different places in its opinion, contrary to the argument that that it predetermined the result today, gives a reading to the amendment which has only a prospective effect. For example, with regard to the ensures election of constitutional offices in all counties, the court said that accurately reflects voters in all counties no longer will have a right to approve a special law for the selection of such officers by another method. The court said of the same clause that it would prevent county charters and approved special laws from abolishing constitutional officers, allowing their office holders to be selected by an alternative method. Did not say that the courts did not say that it would inform voters that it would restore offices already abolished. Of the summary clause removes county charters' ability to take certain actions. The court said that it clearly explains that charters will be prohibited from taking certain actions by amendment if it passes, not to restore constitutional offices. So I think this reflects to Your Honor's question, that the schedule can be read in more than one way, and it has to be reconciled with 1C since there's no explicit repeal, and there's not a clear repeal by implication. Just to briefly review, the Article 1C confers a substantive right on Volusia voters that they exercised in 1970, and the form of government pursuant to 1C pursuant to 1D that has been modified at a time. I do want to address the point that somehow the charter, the special law charter that was enacted by the legislature at that time is somehow inconsistent with the 1G. It was specifically authorized by the Constitution pursuant to 1D, which that section's now been deleted. But Section 1D deals with the legislature's power to preempt, and this, in any case, this is a special law, not a county ordinance as referred to in 1G.
Let me go back to your argument about the effect of Section 1C. Is it your contention that if the charter had something blatantly unconstitutional in it, then that provision would remain operative unless and until a special election was held and it was repealed or amended?
No, I'm saying, no, that's not my argument. My argument is, at least it doesn't reach that far. My argument is that the Constitution specifically authorized the action that the Volusia voters took under 1D, which is pertinent today, and under 1E to abolish the county commission and to establish a county council in place. That was specifically authorized. This is not part of the general preemption, not part of the general home rule power of 1G. That's what I was trying to inadequately to explain. This was specifically authorized, and the voters, 1C says, establishes a charter government which shall not be amended or repealed without their consent. This is you could not abolish the charter, that there is home rule, and you could not abolish the form of government that the voters established. This was specifically authorized. The amendment has retroactive effect by undoing the special law that was passed by approved by the voters in 1970.
And that you're contending is the new legal consequence, as in effect because of this amendment. That's your argument on the retroactivity?
The argument on retroactivity is that it does not do, as the circuit judge said, that reaches back and just simply removes those provisions of the charter. That gives no consequence to 1C. It says that it requires a vote of the voters. It requires a special election and approval by the voters in Volusia and others that may be affected. But particularly is the ambiguity pertinent for Volusia, I might say, because that was a special law approved by, it's also a special law approved by the vote of the electors, and it removes county charter's ability is not what we're speaking of at that point. This was an exercise of the legislature's authority that was approved by the voters.
But this amendment, just to make sure I'm clear, is not seeking to invalidate or undo any of the acts of the officers prior to the amendment. It's just saying prospectively you have to elect these officials.
Correct.
Okay, and so how is that a new legal consequence that flows from the amendment?
Because it reaches back and invalidates the action of the electors in 1970. It says that what they said, notwithstanding Article 8, Section 1C, is of no effect. And after invalidating requires the election of officers, which the Volusia voters had already abolished. Does the court have questions at this point with regard to the jurisdictional question? Otherwise, I'll reserve.
Pardon me for interrupting. The nature of the Miami-Dade County and Broward County charters, since they have more time to comply, are they similar in some respects to Volusia? I'm sorry, I'm not totally up to speed on how they have structured their local governments. Maybe you could help me with that.
In Miami-Dade, it was constitutionally authorized as directly and preserved under the 1968 Constitution. It was there was a charter commission that established what was then called the metro form of government. It gave the vote it gave the legislature less authority with respect to Miami-Dade than us. In some other respects, it's similar to us. They have abolished certain of the constitutional offices. Broward, unlike us, is a charter that was adopted pursuant to general law, and they've taken certain actions that are similar to us, but it derives its authority pursuant to a charter adopted pursuant to general law.
Just out of curiosity, how does this affect Duval County?
Beg your pardon?
How does it affect Duval County? Because their charter is very unique.
Well, I would say not at all.
Because they already have the constitutional officers?
Well, it said that the Duval Charter, as I understand it, it was enacted pursuant to a constitutional amendment that was in 1934, that I think was amended in the 40s, and finally the Legislative Special Act in 1967. It authorized the special law required the retention of the sheriff and the clerk of court, otherwise they could be abolished. And the language with regard to the county charters, I don't think applies to Duval, because it says a county charter, and Duval's is a city charter by special law legislature. It's a municipal charter, and so by the plain terms, I would say that it doesn't apply, although it may not make any difference in
I was
Duval.
just sort of curious how it operates as to other counties, and that one has a unique structure. I think it was a special law, but perhaps
It was a special law pursuant to a special provision of the Constitution.
Right.
And while the notwithstanding clause brings in Miami-Dade, and by my view prevents future action, it does not bring in, while it's preserved under the same provision of the Constitution, the provision of Article 8, Section 1D now says that county charters shall not do that. And county charter, Duval is a municipal charter, and secondly, that provision should not be read to invalidate the legislature's authority under Article 3, because there are things that under Article 3 doesn't mention that in the title or any respect. And Article 3 is a source of authority independent of a county charter. The legislature still has authority that would be prohibited by that sentence.
I have one quick logistical question before you sit down. If you do have to ramp up and do an election next year on these offices, when do you have to start? When does the process of doing that get into preparation? This is a timing question.
The timing question, those candidates would have to qualify beginning now under the law June 8th, beginning June 8th.
Okay, thank you.
And so people are having to take their positions now, and without any certainty of what the office will be. I just say that because while the briefs were pending, the legislature amended to move back to the filing date, the qualifying date.
Thank you.
Thank you.
Thank you, Your Honor.
please the court, I'm Barry Richard on behalf of the Florida Association of Court Clerks and Comptrollers, and by agreement with counsel, I'd like to take 10 minutes.
Okay.
And I'd like to begin with the question asked by Judge Ray. There were 4 subjects in this amendment. The other 3 subjects took effect in January of 2019. Only this one was delayed. It was delayed until January of 2021 for all except Miami-Dade and Broward. And the only rational reason for the delay at all is in order to give counties time, all counties, but particularly those counties that had already made antecedent changes, time to comply. And the only rational reason for giving even more time to Miami-Dade and Broward was that they not only were the largest counties, but they had both made extensive changes to their charters with regard to the constitutional officers. If there was no intention for this to apply to those counties, it could have taken effect immediately. Counsel's argument that the reason that it didn't take effect immediately was in order to keep, as I understood what he said, in order to keep counties from making changes in the interim, doesn't seem to me to really apply here, because if that's what the legislature, if that's what the CRC had intended, they would have done the opposite. They would have made this take effect immediately. The only rational conclusion that can be reached by this schedule is that it was intended to apply to all counties, including those that had made antecedent changes. In addition, if we do not conclude that this applied to all counties, then there are several portions of the amendment that would be superfluous, 2 in particular. The amendment began by striking the language that gave county charters the ability to change the elections and the duties of the constitutional officers, which was Section 6D. That's the only reason they were able to do this. If it hadn't been for Section 6D, they couldn't have made any changes, because the Constitution set forth the manner of election and the terms of elections and the duties of the constitutional officers. This amendment began by repealing that language. Once it repealed it, county couldn't do it anymore. They had to stay with the constitutional duties and election time. But they went beyond that. They had it has a second sentence that effectively deletes any language in existing county charters inconsistent with that. That language would be absolutely superfluous if it didn't apply to those counties that had made antecedent changes. But there's a second provision that would be superfluous in that same area. The 1885 Constitution had granted home rule powers to Dade County, including the power to abolish constitutional officers, which, as we know, what we now call Miami-Dade County, had done. The 1968 Constitution preserved that provision in Article 8, Section 6E. This amendment begins the language by saying, notwithstanding Section 6E, that can only apply to Miami-Dade County. It would be meaningless if it was intended to preserve the ability of the counties to make these changes. Unless the court has questions about the amendment itself, I'd like to make some comments about the ballot summary. As we know, the poll star for the interpretation of constitutional amendments and constitutional provisions in generally is the voter's intent at the time that an amendment is adopted. And the best evidence, I would suggest, of the voter's intent is the ballot summary, which is the last thing that the voter sees before casting a ballot. The ballot summary in this case is clear. It begins by saying that it ensures election of the constitutional officers in all counties. In all counties. That can only mean one thing. That includes counties that made antecedent changes, and you can't read that any other way, so we have to assume that any voter looking at that summary while casting a ballot would never have a reason to assume that counties that had made antecedent changes are not included in it.
Let me ask you a question about the Florida Supreme Court's decision about the accuracy of the ballot summary, and it concluded, or it held, that the summary accurately reflects the language of the amendment, and it says all counties, so you argue it must mean all counties. Why did the Supreme Court then pass for another day the issue of retroactivity? Why is that even an issue if the summary accurately reflects the language, and as you reason, it's all counties?
Well, that's a reasonable question. I think the answer is that the court, not facing this kind of a question, had a whole series of cases before this one came before it in which they said, we're not going to take up the issue of whether or not it applies retroactively at this time, because the only thing that the Constitution tells it to consider is the accuracy of the ballot summary as it reflects the amendment and the single subject question. And they've just all held the line on that. And they've said, well, we're just not going to take anything else up. And I think that's the reason that they said that. The peculiar aspect of this case, which the judge below noted, is that in this case, if this ballot summary, if this amendment was not, and I hesitate to use it retroactive because I mentioned in my brief that confuses things, but if this one did not apply to the counties that made antecedent changes, then the summary would clearly have been invalid. And so the judge below concluded that even though they decided that they didn't want to change the precedent of not addressing it, that implicitly they must have decided that it accurately reflected what was in the amendment. I think that's a reasonable thing to conclude. The last thing I would note is that the next sentence in the summary says removes county charters, and that's a plural possessive charters, it's S apostrophe, ability to abolish, change terms, transfer duties, or eliminate election of these offices. That again would be superfluous and certainly not accurate, because it would have to say some county charters at least, but there would be no reason to go back and strike the language in existing charters if this didn't reach back to those that had made changes. All they would have to do is go with the first sentence, which is we're striking the language that allows them to do it in the first place. So I think it's clear in this case that this amendment in the first place was intended to cover all counties and to give them an opportunity to have time to fix it so they could come to a compliance, and that's precisely what the summary says. So unless the court has additional questions.
I do have, sorry to take up another minute, but is this opinion in a CRC context
Right.
the same as an advisory opinion in a citizens initiative context? Are there limits on what this opinion does? Is it purely advisory? Is the comment about the in all counties language in the summary, is that a determination on the merits?
You mean with respect to the Supreme Court's decision?
Correct, right.
Well, I think they made it clear that they were not deciding on the merits whether or not it reached back. And I wouldn't rely upon the Supreme Court opinion for that purpose, because they did not do that. But I think that for all the reasons I've said, that if it did reach the Supreme Court, I can't imagine how they would not reach the conclusion that we're urging on this court.
Thank you.
Does that answer?
I think so. So basically you're saying it's dicta, but they said it, and they're not going to
Yes,
change
I'm saying
their
I'm
mind.
not relying on that because they made it
Right.
clear that it was dicta.
Right.
But I think they would decide it this way if it reached them. Thank you.
Good afternoon, and may it please the court. My name is Edward Wenger, and I am here on behalf of Governor Ron DeSantis. Ashley Davis, who is with us at council's table, is appearing on behalf of the Secretary of State, and she has agreed to yield her time. She is available, however, if the court has any Secretary of State-specific questions. With the court's permission, I would like to reserve 2 minutes for rebuttal on the cross-appeal issue. Is
So
that okay?
noted.
I'd like to start by providing the governor's position on the merits of the case. While we maintain that Governor DeSantis is not a proper defendant, the circuit court was correct to grant summary judgment in favor of the intervener defendants, largely for the reasons offered by Mr. Richard. Judge Kelsey, to pick up the question where you left off, and I think it was following up on Judge Ray's question, the ballot summary, which is the poll star of constitutional interpretation, does reference all counties, and it seems like it would be the indication to any voter who
No,
voted
wait,
in favor.
let me stop you there. The summary is not in the Constitution, correct?
No, it's not, but that's the best way to determine what the voters thought whenever they were voting, because the voters don't see what's in the constitutional text whenever they take a look at the ballot. So for that reason, the reference to all counties would seem to me to mean all counties to any voter who was going to take that up. And to answer the question that Judge Ray had posed earlier about why it was perhaps that the Supreme Court had withheld deciding that question, under the advisory opinion process, the only legal questions before the court at the time were whether the ballot language and summary was adequate to show up on the ballot that particular year. The legal effect, which we would argue is this particular question we have, is one that was not before the court then. So for that reason, it shouldn't come as a surprise that the Florida Supreme Court demurred on that issue. But very briefly, we believe that the Revision 10 applies and says that all counties, including Volusia, including Miami-Dade, including Broward, will, for most counties starting in 2020, need to elect their constitutional officers. We don't think, and we have argued that this is not retroactive effect because it doesn't undo any previous activity that the County of Volusia has taken. All this does is tell them that in 2020, they'll have to elect their constitutional officers. And under the various provisions of the Constitution, including Article 8, Section 1G, the court's case law interpreting that, and basic black letter supremacy law, any county charter law that's going to run inconsistent to the Florida Constitution must yield. If there are no further questions on the merits, I would like to turn to the cross-appeal issue.
Well, let me ask you this, Counselor. What evidence is there, if any, about the CRC's drafting process here? I don't know whether this ballot proposal just was drafted by staff and never changed. They had to draft a ballot summary as well. I assume there was some discussion among the CRC commissioners about this topic. Is there any sort of legislative, for lack of a better word, legislative history?
There is,
to look
Judge
at
Makar. We have not, it's not in the record here, so I'd be a little bit reluctant to start relying on that, particularly since I'd have to go off of memory at this point. But the CRC did meet over the course of a number of months, and there were public hearings, there were private discussions that actually led to the revisions that eventually were submitted to appear in the ballot. So those do exist. Standing here, I am not in a position to represent.
So we don't know
that.
whether there was a good lobbying effort by, Miami-Dade, and I guess Broward, to kind of give us time, because we realize that we have to change our structure and we have to do it, or whether there was some other accommodation for them.
Like I said, I'd be reluctant to represent one way or the other, whether or not they participate in the process. I can represent to the court that that process did occur and that those public hearings were, from what I understand, rather robust, and there were a lot of debates going back and forth. But I think that the best example of the fact that there was some consideration paid to the fact that Miami-Dade and Broward, both of whom had done away with certain constitutional officers also, would have to elect these constitutional officers is the evidence that the amendment itself gave them additional time to come into compliance with Revision 10 and what is now the amended version of Article 8, Section 1D.
Is it fair to say as of 2025, every county in Florida will have to have these constitutional officers uniformly?
That is our reading of
4-year terms.
That is our reading of the amended version of Article 8, Section 1D.
And the local governments, the counties, have no discretion as to that.
That's correct. That is our position, Judge Makar.
So how does that affect term limits?
How does that affect term limits?
Yeah, if a jurisdiction has a 2-term limit on a clerk of court. If you know, if you don't, I mean, it's okay to say I'm not sure.
That's a question that I hadn't really considered yet. And I guess the question, if you don't mind me asking, is the term limits, I suppose, is that for the
Constitutional officer.
For the constitutional officers. To be candid with you, Your Honor, that's a question that I hadn't thought
That's
of at this
fine.
point.
The reason I ask it is that this was an area where the term limits on local officers had been subject to litigation over the last 15, 18 years.
Right.
And the current Supreme Court position is that because of the powers of local government that they have to kind of craft their own local governments, that they could have term limits,
Mhm.
and that the constitutional limitation, disqualifications from office don't apply. So now that that is all gone, it seems to me it opens up more than just the issues today, but other issues such as term
I think
limits.
so, Your Honor. And with respect, I think that that's a fair question. I think that it's one that is outside the scope of this particular
Sure,
litigation.
sure.
And that's probably the best that I can offer you standing right here when it comes to that particular issue. But you're very right that whenever you have a constitutional amendments, it oftentimes has downstream effects that perhaps people, need to figure out in litigation. Our position here, though, is that the immediate effect, the effect by the plain terms of Revision 10, is that all counties, including Volusia, including Miami-Dade and Broward, will need to elect their constitutional officers starting in 2020 and certainly no later than 2026. If there are no more further questions, I would like to speak briefly about the cross-appeal issue. On page 20 of County of Volusia's answer brief on cross-appeal, under the title Specific Enforcement Duties, County of Volusia lists, sort of in seriatim style, the general executive enforcement duties of the governor that are listed in Article 4, Section 1. In Francati, this court took up an argument by Ms. Francati that the governor is a proper defendant in the suit by virtue of his general executive duty to execute and enforce the laws of Florida. This court said without equivocation, we find no merit in that argument. We would submit to the court that under the principles underlying the Francati decision, they apply just as well here, and they command the dismissal of both the defendant and the Secretary of State.
Well, now, the Secretary of State's responsibilities are far different than the governor's in this respect. And I know you're not here representing the Secretary of State and just the governor's office, but I'm not sure that they're the same and would support your argument.
Well, if Judge Ray, if you have any questions for the Secretary of State, like I said, she is available to answer questions. But I think given the way that this case has been litigated and briefed, a lot of the same responsibilities, they look very similar to what the County of Volusia is arguing with regard to both the governor and the Secretary of State. And we would submit to the court that the arguments that I'm prepared to advance and that we have advanced in our brief would apply just as soon to both of the constitutional officers.
I'm sorry, who was the proper defendant here?
I think that the Secretary of State has taken the position, and we don't want to say for certain. There could be other issues, but it seems to me like the official that could have the most involvement in this would be the County of Volusia's Supervisor of Elections, because the Supervisor of Election is the county official who is responsible for actually certifying the elections that end up down the stream at the Secretary of State's and eventually result in the commissions that are certified and signed by the governor and countersigned by the Secretary of State.
So Volusia County should have sued their local Supervisor of Elections?
Well, like I said, Judge Makar, I don't know for sure if there would be other issues that would arise that would keep that. But,
here's what I'm getting at. Maybe I'm missing something here. If I am, it won't be the first time. But if the governor and the Secretary of State drop out of this lawsuit, who's left?
At this point, we have not made this argument in the briefs, but there would be a question about whether anybody's left because the court was left without subject matter jurisdiction from the outset. That would be our position.
So there was no jurisdiction from the outset?
That's correct. That would be our position, Your Honor. But to answer the question, though, it's not necessarily that the County of Volusia would have to sue its own Supervisor of Elections. As Mr. Eckert has mentioned before, there are two County of Volusia voters who are appearing in their individual capacity. And standing here before the court, I see no reason why neither of them could sue. And by all accounts, they have every inclination.
But the defendant, I'm missing it. Where's the defendant?
The defendant would be the County of Volusia Supervisor of Elections. It would be the individual.
Who wasn't sued? So maybe I'm just spinning in a circle here.
Yeah.
But if we determine that neither of the defendants, the governor or the Secretary of State, were proper, then isn't the judgment a nullity?
That would be our position, absolutely, Your Honor.
I mean,
we would say the entire
ruling
thing should go away. Absolutely.
Okay.
Our position is that from the outset, there was no subject matter jurisdiction because the County of Volusia and these two individuals decided to sue entities who had no enforcement power over a self-executing constitutional provision, and they had no legally cognizable antagonistic interest in this case. If one of the two individuals would have decided to sue their county official for violating, in their view, the Constitution, that might be a different story, but that's a decision that was not made here.
So if we go with your reasoning, then the judgment is dissolved, and Volusia County has to sue one of these defendants that you've just.
That would be our position, is
Okay.
that at this point, since there was no jurisdiction, no subject matter jurisdiction over either of the defendants that were sued from the outset, our position at the outset is that, no, at this point, there was no subject matter
So the
jurisdiction.
trial judge's ruling is just an advisory, it's a nullity.
That's correct. Volusia County has, because they sued defendants without an antagonistic interest, is asking for an advisory opinion from the circuit court, and we would submit that the court should dismiss on those grounds. If the court has no further questions, I would like to...
I do have a question for counsel for the Secretary of State, so I'll ask Madam Chief if we can have a couple minutes to do that.
Absolutely. Any more
Okay.
questions for counsel for the governor? No? Okay, thank you.
Hello, Ashley Davis on behalf of the Secretary of State. I'd like to just go ahead and start with addressing Judge Ray's question. The Secretary of State's responsibilities here really are not any different than the governor's responsibilities here.
Well, let me stop you right there and
Okay.
just get to my question so we don't go too much over. And that is, what about the statutory duty of the Secretary of State to be in charge of the statewide interpretation and implementation of election laws?
She certainly has that duty and
Okay,
responsibility.
why doesn't that make her a proper defendant?
It's not alleged as the basis for her proper party
Does it have to
defendant
be?
status.
Are we limited to that?
Even if it was alleged, it wouldn't make her a proper party here because it's not at all implicated in this case. The controversies arise
Okay,
all the
wait,
time.
let me ask you again. How is this case not about the interpretation or application of statewide election law when we're looking at a statewide, a provision of the Constitution that applies statewide?
Well, if you're referring to the broad constitutional duty of a state to do something that might be implicate specific responsibilities, the broad constitutional duty of the state that has led to proper party status of a governor or secretary of state in the past have been the constitutional duty to redistrict every year after the decennial census. It's been the constitutional duty of the state to adequately fund a uniform system of free public education. This revision 10, what it does is quite different. It's whether local county officers must be elected and whether local charters cannot allow an alternative method of selection. That's something that's quintessentially local. It's not really, it happens to be in the
Well,
Constitution.
it certainly has local application, but if we're just talking about the, academic interpretation of this new constitutional amendment, that could conceivably apply to a large number of counties. So it have more than just one county application.
Sure.
But
but-
if they had sued the Volusia County Supervisor of Elections, could the Secretary of State have intervened?
No, I'm sorry?
If they had named as a defendant the local Supervisor of Elections, could the Secretary of State intervene in that?
Could she intervene? That would be a different analysis than whether she would be a proper party defendant to be hailed into court without
Maybe.
her seeking permissive intervention. So I think that's a different kind of a context. I think the point to focus on is that Volusia hasn't alleged whether or not it's even going to hold an election pursuant to Revision 10 or not hold an election at all. Those allegations haven't been made, and there's been no implication of what kind of election they're going to hold. And this is where it comes into the point that controversies about whether there should be an election or what kind of election should be held are quintessentially properly brought against the qualifying officer. The Secretary of State is not the qualifying officer for these county offices. That's the Supervisor of Elections. And in our brief, we raised the possibility that most likely, while there are many ways that a proper controversy could come before a court so that you could resolve this constitutional issue, this is not one of them. Most likely, there are many situations in which the supervisor would be a proper defendant. She could decide to hold an election and qualifying pursuant to Revision 10, and the tax collector, who is currently appointed and not wanting to move to a constitutional officer elected setup, can file suit against the supervisor as qualifying officer to stop the election. That constitutional question about whether Revision 10 applies and how it applies to Volusia's local charter would then be ripe for consideration. But we don't even have the allegations one way or another if Volusia is even going to have an election under Revision 10 or not. That is quintessentially an advisory opinion before the court.
But
There
don't you
isn't
think
any-
Volusia County, I mean, this is not so hypothetical like in the blind trust case. I mean, don't you think these individuals need to know whether they're going to have to hold an election?
Well, they're going to need to know whether to hold an election by making a decision whether they think they're supposed to be holding an election or not. They need to pull the trigger and decide which it is. If they don't think that the Revision 10 applies to them, then don't hold an election and be subject to a challenge to open up qualifying and hold an election under Revision 10. There could be many circumstances where other parties could be proper defendants. The point is that as alleged and under the circumstances now, there is no crystallized set of facts to make this a justiciable controversy rather than a quintessential advisory opinion on, we don't know what to do, court, please tell us. And that is the position that Volusia County is in this case.
Do you agree? Do you agree that if neither the governor nor your client or were proper defendants here, that this case, the judgment below is a nullity and that we should vacate it?
Correct.
And that the proper approach is for Volusia County to sue the supervisor?
That would be one possible way. I think first the supervisor needs to decide whether she's going to be
Well, if
holding
the
an election.
supervisor says, I agree with the plaintiff county and enter judgment accordingly,
If the supervisor decides not to hold an
I
election,
guess we'll be on appeal then, right?
then a
Again.
candidate that would like to seek a constitutional office could again file suit against the supervisor, and that constitutional issue would be ripened before a court.
The Secretary of State was a named defendant in the original 2018 litigation on the revision, correct?
Correct.
Properly so?
Properly so
Oh.
in that instance. When it comes to whether a ballot statement it meets the constitutional requirements of single subject and is not misleading and tells voters the chief purpose, the Secretary of State is a proper defendant when that amendment or revision is already on the ballot. In the CRC situation, CRC votes to put amendments on the ballot, they go straight to the ballot. And if anyone wants to knock that revision off the ballot, the Secretary is the defender of that ballot and would be subject to suit. In the initiative petition context, when it's an advisory opinion being sought of the Supreme Court, that initiative petition has not yet made ballot position. There are many hundreds of thousands of signatures before that point. That's why it's an advisory opinion. It's not yet on the ballot. The Secretary is not the defendant in that case. There really isn't any defendant because it's purely advisory. The Secretary is, however, part of that process. She certifies the sufficient number of signatures have been gathered and sends that notice to the Attorney General, who then petitions the Supreme Court. So there are very many different layers to that.
Thank you.
Any further
That's all I have
questions?
for now.
No, thank you.
Thank you, Your Honors.
Okay, Madam Clerk, I will allow 2 minutes to rebuttal for the cross appellants, and of course, add whatever time to counsel for appellants side that we went over for the appellees. Thank you.
Your Honor. First, briefly, as to the jurisdictional question. The Florida Association of Court Clerks and the Florida Tax Collectors Association intervened and were made parties defendant. They were parties at the time the court entered final judgment. They participated in the case. They've indicated they have an adverse interest. They outlined that. They are before the court, and the court has jurisdiction.
Who is that?
Mr. Richard for the Florida Association of Court Clerks, Mr. Young today for the Florida Tax Collectors Association.
They're made party defendants?
They were made parties defendant. They intervened. They were made parties defendant.
Okay, so I've got the final summary judgment here. I guess I missed it because I don't see
Actually,
it.
it was their motions for summary judgment that the court took up and granted.
So you disagree that
Well,
it's a nullity as to the two parties perhaps, but not a nullity because there are these other
perhaps a nullity
defendants?
I'll return to that, but perhaps a nullity insofar as
Well,
the
but
government.
wait, could they have been sued initially and that would have been, they wouldn't have been able to effectuate?
They could have been sued initially, but the appropriate parties, and I would still contend the appropriate parties are those that we named. Not the only appropriate parties, but they were proper parties.
So there's 4 defendants, you're saying?
There are.
2 private organizations and 2 state actors.
Correct. They were allowed to intervene and they were made parties defendant. They argued the case below. It was the Florida Association of Court Clerks that filed a motion, and the tax collectors joined in.
But if you'd sue the two private parties, I assume that, I mean, they don't have any power to effectuate anything.
Well, they indicate that they were allowed to intervene because.
I know, but I'm trying to figure this out, which is if they were the only two defendants sued, the court's ruling wouldn't really have any effect because those two defendants really can't do anything.
The court clerks indicated that it would affect their duties, perhaps somewhat ironically, statewide, but not in Volusia because our charter was adopted by state, by special law.
Okay.
The tax collectors indicated and the court found that they had sufficient interest in the advocacy for election of tax collectors in every county. The court found that they had an interest to be heard, they participated, they had an antagonistic interest, and the court, and the cases we've cited in the brief indicate that, I think, a fair reading that the court had jurisdiction when it, in this case, to enter the order. I'll return to the governor and the secretary in a few minutes, but the court has jurisdiction, and frankly, the parties need a declaration. We're not entitled to have doubt removed. I want to briefly touch on Mr. Richards' argument. My friend Mr. Richards for the Association of Court Clerks says that all counties in the ballot summary cannot be read any other way. But the Supreme Court did provide an alternative reading. And perhaps this indicates, it also bears on the statewide nature of this. The two sentences are, rather it provides that Amendment 10 ensures election of constitutional officers, and this language accurately describes its effect. Because it would prevent county charters or approve special laws, the legislature's power to do this in a non-charter county. Regardless, you could do this in any of the counties across that could have done it, in any of the counties across the Panhandle that did not have charters, or any other place in the state for that matter. Again, because it would prevent county charters or approve special laws abolishing constitutional officers, allowing for those office holders to be selected by an alternative method, Amendment 10 would therefore ensure, quote, that such officers would be elected in all counties. The all counties is the set of charter counties and non-charter counties. It's the exercise of the charter ability and the legislature's ability, prospectively. With regard to and I think this bears upon the ambiguity. The argument was the ballot language is, the court said that the ballot language is also not misleading for failure to identify additional constitutional rights that will be affected by Amendment 10. The Supreme Court's jurisprudence, indicates that you're supposed to tell voters if you're eliminating a constitutional right. But the Supreme Court said in response to that, the summary does not need to further discuss its effect on voters' abilities under Sections 1C and 6C to amend their county charter, because it clearly explains that voters will be prohibited from taking certain actions of Amendment 10. Voters will draw the logical conclusion that they will be permitted to amend their charter, and they will not be permitted to amend their charter in a manner inconsistent with this amendment. Voters, and then again, the court continues, the summary also continues that to ensure election of constitutional officers, this accurately reflects that voters no longer will have a right. So, and then with regard to the ability, it does not say that it removes the prior exercise. It says it removes the county charter's ability. Prospective. That doesn't say anything about what has already transpired.
So your position is they grandfathered you in and pulled up the ladder?
That if you had made changes under the prior version of Article 8, Section 1D, or in the case of Miami-Dade, 1C preserves those changes. And it's not repealed by implication. It's clearly not. There's no mention of it. And the Supreme Court, I'm just making the argument here that Mr. Richards says it cannot be read any other way. Well, the Supreme Court did read it another way. And if it can be read another way, it can be, Article 8, Section 1C must be read in pure materia, and that the prospective application must be clear and unequivocal, so clear that it can't admit any other reading. Now, with regard, I just want to return to your point, Judge Makar, with regard to the CRC, that in this context, the Supreme Court has never substituted comments from an individual member for a clear and ambiguous text, constitutional text and ballot language. The voter's intent is, if you read this, it's the voter's intent ultimately, but if the language is unclear. But this language indicates, and it's entirely in present tense, and it can be read for only prospective effect, and that's what the only sentences in the Supreme Court's opinion did just that. Now, with regard to the jurisdiction, Francati, this court's Scott versus Francati case obviously was a nursing home statute, which had specific, my recollection of the cases, and the court probably recalls it better than I, but the duties could be assigned, were evident to another officer. The governor was named, although he didn't have any specific duties with regard to this. So this is the Florida Constitution, obviously. That's why we're here today, and that's why the court perhaps has granted extra time. The governor's no mere bystander to the Florida Constitution.
So is it your position that any time constitutionality is challenged, the governor can be hauled into court?
No, not just, that court doesn't have to reach that conclusion.
Well, what is
the governor has
specific cognizable interest that the governor has in this issue?
Well, he has to do. He has the duty, for among other things, to issue commissions to specific officers. He has.
Counsel, are we limited to that basis? If
No.
we found that either of these defendants had some power or duty that was implicated, could we go beyond what you alleged as the signing of the commission?
The governor is the governor, and while we, in the argument below, we allege that he has the duty to see that it's properly implemented, to see that not only to issue commissions for constitutional officers, but to oversee the implementation of Amendment 10 as part of his executive duty. And I would suggest that the Coalition for the Adequacy versus Childs says just that. The court ruled in two different ways. In the Irvin versus Childs case that we talked about, I believe it was the secretary spoke about whether the attorney general could appeal, but that case was initiated by a candidate, Peasley Streets, that against state officers for what the court said was a self-executing amendment. It's the state's position reflected through the governor and the secretary of state is that if it's self-executing, no state official has responsibility, even though the governor could suspend, even though the secretary could sue, even though the secretary is supposed to be able to tell the election officials. It's such a hands-off approach. It's respectfully, it would, if we took the opposite position, as we said in the brief, we're going to just go ahead with our charter as we think we're entitled. Well, we'd find out that the governor has authority if he believed otherwise, and that the secretary has authority. We're entitled to have doubt removed. Thank you.
Thank you, counsel. Cross appellant, you have 2 minutes if you need it.
Thank you, Your Honors. I will be very brief, and I'll limit this just to the cross-appeal issue. The gravamen, as I understand Mr. Eckert's argument, is that the governor's general executive and general enforcement authority confers him proper defendant status in this case, and we would submit that, you know, the spirit, at least, of Francati sort of contradicts that line of argument. It's, like I said, we discussed at the front, the Francati sort of rejected out hand the argument that general executive enforcement authority are sufficient to hail the governor in a court. With regard to the two more specific responsibilities that have been referenced in this case, the signing of commissions is a ministerial act that the governor undertakes after and only after the elections are certified. The decision about who to certify an election, as both myself and the Secretary of State's counsel have pointed out, is the county supervisor of elections. The governor's role in signing commissions is not